evening, everyone. Namaste. A very warm welcome to all of you present here. In this room, we have some of the brightest minds of our legal fraternity. Please join me in welcoming the chief guest of this evening, Hon'ble Mr. Justice Surya Kant, and our guest of honor, Hon'ble Mr. Justice K.V. Viswanathan. Unfortunately, Justice Surya Kant is slightly under the weather, so he is unable to join us here right now with us. But he's been extremely kind and is going to grace us with his presence virtually. And he will give his speech through us. He'll join us on video. Welcome, sir. We are honored to have you join us with us this evening. With your Lordship's permission, we'd like to start this evening's event. Distinguished guests, esteemed colleagues and friends, it is my great pleasure and honor to welcome all of you to the release of the book, Sarkar Specific Relief Act. Your presence here today is greatly appreciated and adds to the excitement and significance of this event. We hope that each part of today's program will inspire and engage each one of you. As we begin, I'd like to invite Sidharth to please come on stage and share his thoughts with us.
Honorable Mr. Justice Surya Kant, Judge, Supreme Court of India. Honorable Mr. Justice K.V. Viswanathan, Judge, Supreme Court of India. Honorable Mr. Justice Aftab Alam, former Judge, Supreme Court of India. Honorable Mr. Justice Sanjeev Banerjee, former Chief Justice of Madras and Meghalaya High Courts. Mr. Sudipto Sarkar, Senior Advocate. Esteemed seniors from the bar. My friends and well-wishers and colleagues from national and international law firms who are present here in person and those who are joining us virtually. Ladies and gentlemen, Namaste and a very good evening to all of you. It is my proud privilege and honor to welcome you all to the launch of Sarkar Specific Relief Act. It's Sharad Purnima today. इस दिन का विशेष महत्व है. धार्मिक मान्यताओं के अनुसार इस दिन चंद्रमा 16 कलाओं से पूर्ण होकर रात भर अपनी किरणों से अमृत वर्षा करता है. That is, it is believed to be the only day in the year when the moon appears in its full glory, radiating with all 16 kalas or phases. And therefore, what better day to launch this book? This book is a monumental work and for the past several decades has been a valuable text for members of the bar and bench. Law relating to specific relief is a cornerstone of Indian civil law and addresses the remedies available to aggrieved persons in cases where civil or contractual obligations are not fulfilled. In an era where contracts form the bedrock of commercial relationships, understanding the nuances of this law cannot be overemphasized. The law relating to specific relief has undergone several amendments, most recent in 2018, reflecting the evolving nature of the Indian jurisprudence and the need for legal frameworks to adapt to the changing realities and the contemporary realities. These amendments have introduced significant changes, more particularly with respect to the reliefs which are available to a party, discretions exercised by court, and enforcement of contracts. Taking into account all these changes, this book aims to provide a comprehensive analysis of the Specific Relief Act, blending theoretical insights with practical applications. Our objective in this updated edition is to demystify the complexities of the Specific Relief Act, offering the readers a clear and structured understanding of its provisions. As the readers embark on the journey of learning the law relating to specific relief and maybe unlearning some of the concepts which may not be relevant today, We encourage them to engage critically with the content, reflecting on how these legal principles can be used to advance justice and equity. Ladies and gentlemen, it is my honor to present to the readers the 19th edition of Sarkar Specific Relief Act. For a first generation lawyer, born and raised in a small town in Himachal Pradesh, this is a dream come true. This is my fourth book under Mr. Sarkar's tutelage, and I cannot thank him enough for trusting me and giving me these opportunities. Sir, your guidance, wisdom, and unwavering support have been instrumental in shaping my journey, and I'm deeply grateful for the impact you've had both on my personal and professional growth. I express my heartfelt thanks to the entire LexisNexis team, particularly Arjun, Shalja, Kanika, for their support and assistance. A big thank you to JSA for the opportunities and the platform it provides. Thank you, Mr. Sagar, for your vision and creating this remarkable institution. A special thanks to my able colleague Kunal Seni for his untiring efforts and support. Without his cooperation, dedication, and interest, this project would not have been possible. Last but not the least, I'm grateful to my team and my family for their constant encouragement and love. It is my sincere hope that this updated edition contributes meaningfully to the discourse on specific relief and serves as a reliable guide to all those who seek to navigate the intricate landscape of Indian civil law. आप सभी का एक बार पुनः इस पुस्तक विमोचन समारोह में बहुत बहुत स्वागत और अपना बहुमूल्य समय देने के लिए धन्यवाद और अभिनंदन.
Thank you, Sidharth, for your opening remarks. If I could now request Mr. Sarkar to share his insights and reflections on the journey of this book. Please, sir.
Justice Surya Kant, Justice Viswanathan, Justice Alam, Justice Indira Banerjee, Justice Sanjeev Banerjee, Ms. Joyashree Burman, a celebrity from a different walk of life altogether. We are grateful. My colleagues from the bar, ladies and gentlemen, it's always good to see some familiar faces whom I don't get to see all that often anymore, unfortunately or fortunately. Welcome to this launching of this edition of this book. This book is, the first edition came out over 100 years ago. There are several law books in this world which are as old as 100 years, but I'm told by my friends and colleagues, there is perhaps none where the same editorial generation in the family is going on for over 100 years, which is probably unusual. The first edition was on the 1877 Act, which was replaced by all of you know all this, so I won't get into the details. The second one, of course, was the 1963 Act came in. Now we have the amendment. Now, most of you will be able to see what is there in the statute, what is written there. But when I saw the amendment, a few thoughts came to mind. What are these amendments all about? Large bulk of the law, of course, would become no longer relevant in view of the amendment which have come about, which is prospective. But as long as cases remain under the old statute, pre-amendment, that law will remain relevant. But the question which came to mind was, does it affect some fundamental points of principle in our legal system or not? By and large, we are aware that the legal fraternity in the world is divided into two branches and two countries of legal system, the civil law countries and the common law countries. The civil law countries came down from the Romans, which was settled by Emperor Justinian in the 5th or 6th century AD in Constantinople, now Istanbul, and Roman law has more or less remained the same, primarily because the Romans were no longer there after that. But of course, the civil law countries have modified it in some form or the other. One of them, of course, was the Dutch. So there was a limb of a Roman Dutch law, and you may find semblance of it in South Africa or Sri Lanka or Indonesia, which are former Dutch colonies. But so far as common law is concerned, Roman law, despite the William the Conqueror in 1066, Roman law did not enter England for whatever reason. Common law got settled for the common people of England by Henry II in 1292. And if you are really interested in how it came about, there is a classic of Pollock and Maitland, History of English Law, which will trace you from the beginning of English law under the Anglo-Saxons to 1292. If any of you ever have the time to give up your love for the Luca, you'll probably be able to go and have a look. Now, it was found that the common law was very rigid. So the average man was apparently not getting justice. So they started petitioning the Lord Chancellor, who was the head of the judiciary in England, historically and even today, but perhaps a little change now. And a law of equity developed, which came to be known as the Chancellor's foot. So whatever the Chancellor decided, as long as his foot, the law was developed. But then, at the time of Bill of Rights in 1688, when the English king's powers were curtailed, the Chancellor's foot was also removed, because Chancellor's power also got curtailed. And then we had our 1877 Act. Now, that is the historical part of it. So far as the only distinction, of course, is this. I'm not sure whether the expert committee which prepared a report on basis of which the amendments have been granted realized what they were doing. With civil law and Roman law is inquisitorial as we know it. The judge plays an active role in the whole judicial system. He tries and gets into the system between the parties and try to do justice. In the common law system, which we call acquisitorial or adversarial, the judge sits and decides dispute between two parties. He is not meant to play an active role in the matter at all. In fact, there are many principles which we have forgotten over the times. A judge is not meant to refer to any material or any judgment which he has not put to the counsel during the course of the hearing, because that really hits against the principle of natural justice, which you all know, that a party has not been heard on a judgment relied upon by the judge. So, but then now the question arises, I will just only deal with one section which will give you an indication, section 14A, which has now come in. It empowers the court to appoint an expert on his own, apparently for suits under this act. Now, I did not know that there was a concept of having a suit under the Specific Relief Act. I thought Specific Relief gave some reliefs to, if you can claim it in any suit of any kind that you like. But however, the legislature and the expert committee thought that there could be suits under this act, so perhaps we'll have some suits under this act, I don't know. But the expert point, of course, appointed by the court, goes against the very system of the common law principle. The judge is not meant to play any role. Difficulty, I suppose, was, I think they must have got it from the Arbitration Act. Because the Arbitration Act has a similar provision. But we always forget that arbitration is a contractual remedy. It's a contractual forum. As long as the parties do not violate any principles of contract, they can put up any sort of tribunal that they like. In fact, Arbitration Act provides some of them, like ex equo et bono and so on and so forth. So we have got this amalgam of inquisitorial, arbitration, and common law jurisdiction in this act. Now you have to now decide how to go about it, that it will be an island in a common law country, suits on specific relief of a special kind, which people will have to deal with. Well, that's how it is. Now I have to thank, of course, all of you for being here, wasting your time, listening to all this, to start with. Now I have to also thank Sidharth, because without his energy and effort, nothing can happen. I mean, he's the person who does everything, who generates everything, prepares everything. He's the energy. And of course, now the LexisNexis thinks that he's also become an excellent editor, because its most amusing thing is, I'm looking at the book at the launch, because I have not seen the book. Because the LexisNexis has now realized that Mr. Sidharth Sethi, young and energetic, is more required than I am, which is perhaps correct. I mean, I will not dispute that proposition. But that's really what has happened. So therefore, I have to thank Sidharth to taking all this, taking all the credit. Ladies and gentlemen, whatever you see here is all his doing. Nothing is mine. I am only being asked to speak, which also I don't like to do. Thank you very much.
Thank you so much, sir. I'd now like to invite our guest of honor, Honorable Mr. Justice K.V. Viswanathan, to please address this august gathering.
Honorable Justice Uftabalam, Judge Retired, Supreme Court of India. Esteemed Sister, Honorable Justice Indira Banerjee, Judge Retired, Supreme Court of India. Chief Justice Retired of the Madras and Meghalaya High Courts, Justice Sanjeev Banerjee. The bridegrooms of the evening, Sudipto Sarkar ji and Sidharth Sethi. Distinguished senior lawyers, advocates, ladies and gentlemen, a very good evening to you. At the outset, let me congratulate the authors and the publisher for bringing out the 19th edition of Sarkar's Specific Relief Act. I think, as is often said in our profession, a good lawyer is one who not necessarily who knows the law, but who knows where to locate the law. But a good lawyer can only locate the law if he has a good set of treatises and tomes to back him. And I think in that galaxy of books, Sarkar's Specific Relief Act has already had a pride of place, and it's only fitting that close on the heels of the 2018 amendment to the Act, the 19th edition, comprehensively covering the case law and dealing with the position of law in other jurisdiction, is brought out. So in that sense, the book is timely, and it is bound to prove to be an invaluable asset to the members of the legal fraternity, to students in the judicial academies, and all those concerned with law in any manner whatsoever. The book, I had an occasion to browse through it. I can't claim to have read it in any great detail. Is neatly structured. It is divided into 8 chapters. You will find the chapters from recovering possession, famous section 6, and the case law that arise thereunder, the amendments which have enhanced the locus standi, specific performance of contract, rectification of instruments, rescission of contracts, cancellation of instruments, declaratory decrees, injunction, and perpetual injunctions. It also deals with the amendment. The most famous of it, of course, is that section 20, and the discretion is no longer there. It is shall decree a suit for specific performance. But as you are aware, and as the book rightly captures, I was looking for it in my quick search, even under the old law, it was not unguided discretion. The Supreme Court in several judgments, ultimately in K. Prakash versus Sampath Kumar, had a brief association with it at the admission stage, but couldn't argue it finally because some other case holding up. My memory serves me right, the judgment of Justice Iqbal, following the principle in Rooks, and I'll just place that passage. This was always the law. Discretion is a science not to act arbitrarily according to men's will and private affection. So the discretion which is exercised here is to be governed by rules of law and equity, which are not to oppose, but each in its turn to be subservient to the other. This discretion in some cases follows the law implicitly, in others allays the rigor of it, but in no case does it contradict or overturn the grounds or principles thereof, as has been sometimes ignorantly imputed to this court. That is a discretionary power which neither this nor any other court, nor even the highest acting in a judicial capacity, is by the Constitution entrusted with. The idea is that it's not a whimsical discretion. Court will weigh the several factors. And that is why, for specific relief, commentaries become extremely important, because it is substantially case law driven. And what is fascinating about specific relief, not that you can mention it in the same breath as the Constitution, just as a Constitution is an organic document, the specific relief also, in terms of the application of legal principles, has had to keep pace with the times, and we'll deal with it a little later. One of the more prominent instances is the change of law with regard to whether a title claim on adverse possession could lie at the behest of the plaintiff. And the book rightly captures that after Ravindra Kumar Grewal, what was originally known as the idiom that adverse possession could at best be a shield and not a sword, is no longer the governing principle. But I want to share some personal experiences as to how textbooks on specific performance have helped one personally, because the advantage when you do a specific performance case is, except in cases of big parties, as a junior, these are cases which gave you talk time in court, because very often individuals who come would not be in a position to engage a senior. So particularly in the Supreme Court, that gave you an occasion to look up the law and argue it. And in that process, one learned that in 1992, in Chandrani, the Constitution bench sat and said, specific performance of movable property, time was not the essence. But then, as they say, cessante ratione legis cessat lex ipsa. The reason for the law ceases, the law itself ceases. So with land becoming scarce and the price skyrocketing, then came in Sharadamani Kandappan, I remember, which is Ravindran, a very accomplished judge, held in great esteem by the legal community. He said that with prices having shot up and land becoming scarce, could no longer be said as a general rule that time is not of the essence. There have been other instances where case law has helped. Section 16 then said, it also says now, that you must plead that you are ready and willing. And very often, faced with an objection that there is no such pleading, you suddenly rustle up the papers and see the para, the first para, the second, third, fourth para, to see if there is something there, and then you have case law which supports you there. If you have AUSEP of 1969, you also have, I think, century spinning, if I remember correct, saying that you then read a plaint in its entirety and then see whether there is a pleading to the same to the effect of being ready and willing. And then what happens if in an agreement, I'm emphasizing this to show that how these commentaries are extremely important, because many of the solutions you will not get in the neatly arranged 38 or 39 sections of the statute. You will have to look for the judge-made law. What happens if the agreement says that subject to the permission of the municipal corporation, could a specific performance be granted And then you will have the case law of the Supreme Court. I don't remember the name. Was it Chandanvati versus Vidyavati Maten, which said you could have a decree which would say that subject to the condition of the statutory authorities or the municipal authority permitting. These are things which you will only get by the growth of case law. And remember an instance briefing the legendary Mr. Fali Nariman. We had a defamation suit and had gone there early morning to his office with the plaint, with an injunction restraining the continued publications. When do you injunct? When do you injunct free speech? So the first thing he asked was, did you send him a notice? We said yes. Did he justify it in his reply? He said yes, he has justified. He said then the law is that if he justifies, then your remedy will be damages. You have law for that. You pick up the rule, you pick up the exception. That is why books in this kind of subjects are extremely important. There was a client of mine who had a decree subject to condition of paying in a certain time, and there was a 2-day default or a 3-day default, resulting in Section 28 application in the Supreme Court for rescinding the contract by the other side. And then one had to look up the law and say when delay could be, time could be extended, when it could be condoned, when rescission could be, prevented. Then the vexed question as to whether specific relief prayer itself would imply a prayer for possession. Supreme Court had to pronounce on it. Babu Ram, I think. So this is one subject which is extremely vital. And I am sure from listening to you, Mr. Sudipto Sarkar, that 14A would apply to suits under the Act. And I checked up the sections. It would apply to Section 6. It would apply to the declaratory suits under 38 and the injunctive relief, because this is virtually the the Bible which determines and which lays out the parameter for predominantly civil actions in court, and it has been so for centuries. So the important thing is that the law keeps evolving, the law keeps changing, and it is important that practicing lawyers, and it's praiseworthy that they have taken out time. It's one passage of mine, if Chief Justice Banerjee finds it ad nauseum, pardon me, we were at a book release, but I am never tired of citing that of Lord Gough in Spaliada. Of course, he was then talking of academic lawyers and how the collective joint venture between academic lawyers and practicing lawyers is a joint pilgrimage in pursuit of the unattainable perfection. But here you have active practicing lawyers, or some of them who are very active and who have chosen not to be that active and devoted to academic work now, coming together to share their experience, give their insights. I think this is a book which you will all treasure, the legal community will treasure, and I wish the authors many more books to their pen. Sandeep just mentioned that it is his 4th book. Book, they say, is like a child to an author. But this is one area where there is no family planning. So you can have any number of them. And I wish you all success, and I congratulate you. And I am very happy to be part of this function, releasing this book. I wish the book all success, and a very good evening, and thank you very much to the audience here.
Thank you so much, sir, for sharing your thoughts with all of us. As we move forward with our evening's event, I'd request our chief guest of this evening, Hon'ble Mr. Justice Surya Kant, to now address this gathering. He will join us virtually, so we'll just connect.
I My esteemed colleague, Justice K.B. Viswanathan, Judge, Supreme Court of India, Mr. Sudipto Sarkar, Senior Advocate, Mr. Sidharth Sethi, Advocate on Record from the Supreme Court, both the authors of the book which is being released today, a very distinguished members of the audience, ladies and gentlemen, very good evening. My sincere apology that I am not physically present along with you at the venue, as I am down with mild seasonal fever. There was persistent dry cough, which I thought that it would be very embarrassing if I come there personally. So I thought that I will share my views on the book online. I am delighted to be with you at the launch of the 19th edition of Sarkar's Specific Relief Act. I extend my heartfelt congratulations to Mr. Sudipto Sarkar and Mr. Sidharth Sethi, who have really dedicated so much time and effort into providing a truly remarkable revision to one of the monumental legal commentaries of our time. I would also congratulate the publishers for having organized today's event. To say that Mr. Sarkar's commentary on the Specific Relief Act 1963 is an authority on the subject matter would be an understatement. We need not look further than the fact that this guide is now in its 19th edition to understand its true import and significance. Mr. M.C. Sarkar penned this lucid manual on one of the most complicated statutes in civil law back in the 20th century, and its enduring legacy is but one indicator of its true value. Since the original publication over the course of half a century, this book has been many contributors and collaborators who have constantly sought to perfect it and better it, always making sure that the commentary is keeping with the times and the latest developments. For decades, Sarkar's Specific Relief Act has been a beacon of clarity and authority, guiding countless professionals through the intricacies of specific relief. My brother Viswanathan gave so many examples, and he gave certain practical instances where how the books play a very remarkable role in understanding the nuances of day-to-day practice. This indeed a remarkable book, rooted in a deep understanding of legal principles, continues to uphold and re-infuse trust and reliability that the Sarkar series has come to represent. And today, more than ever, its relevance is understood and must be underscored by the significant changes in our legal landscape, especially the transformative 2018 Amendment to Specific Relief Act, which the edition specifically takes great pains to address and incorporate. I believe the 2018 Amendment is a paradigm shift in the law of specific performance of act. It marks a significant departure from the framework established by the original 1963 Act. The earlier approach, as we recall, my brother Viswanathan has very eloquently cited a Supreme Court judgment highlighting that even in the earlier case law also, as the case law developed, even the 1963 Act was construed as the specific performance will be the normal relief and damages will be an exception. But somehow or the other, the original Act was leaning heavily towards damages as the primary remedy, with specific performance considered more of an exception. However, the 2018 Amendment revolutionized this by amending sections 10, 14, and 20 of the Act, thereby shifting the emphasis. Now, specific performance has become the rule, and damages serve as an alternative remedy. This shift was not merely a procedural change, as I believe. It's a philosophical one. It represents a profound transformation in how we think about contractual obligations and remedies in our legal system. The amendment reflects a modern understanding of the commercial landscape, and it aligns with the growing complexities that have emerged as India has rapidly developed into a global economic powerhouse. India truly seems poised to take its rightful place at the forefront of the global fora. One of the main drivers behind this amendment was the need to encourage foreign investment. The previous regime, which emphasized damages over specific performance, often led to uncertainty in the enforcement of contracts, something that understandably discouraged both domestic and international investors. The shift towards specific performance offers greater certainty, ensuring that contracts are not easily disrupted or terminated at the whim of one party. By providing a stable legal framework, this amendment bolsters investor confidence and underscores India's commitment to becoming a business-friendly nation. The expert committee set up for the purpose of reviewing the Act in its report, I believe, recognized the increasing complexity of large-scale projects, especially those involving government agencies and public-private partnerships. Contracts related to infrastructure development, particularly those of national importance, demanded a legal regime that prioritized completion and timely execution. This is precisely what the 2018 amendment sought to address. The amendment goes even further by providing an exhaustive list of infrastructure projects covered under this statute. This ensures that courts and litigants alike are clear about the kind of projects that enjoy this protection, leaving no room for ambiguity. Timely completion of these projects is now seen not only as a matter of contractual obligation, but also as a matter of national interest. As India stands at the brink of exponential economic growth, this amendment is not just about legal reform. It is about creating the foundation for our country's future, both economically and legally. By ensuring that specific performance is the norm, the amendment instills a sense of security among both domestic and international investors. This legal certainty is critical as we seek to attract greater foreign investment, a cornerstone of our ambitions to become one of the world's largest economies. Contracts, particularly those of great economic significance, must be honored and enforced in a manner that is predictable and reliable. A nation's legal framework is often one of the first things investors would examine before committing to large-scale projects. The confidence that our laws will be enforced and that agreements will be upheld as promised is what sets India apart as a prime destination for investment. The Specific Relief Act, in its new avatar, is a testament to India's commitment to maintaining a legal regime that fosters growth and development. A society that places value on the sanctity of agreements is a society that values trust and integrity. I personally believe that this is the kind of society that India has always been, where trust is baked into everyday life, whether in commercial dealings or personal affairs. Contracts are fundamental to the smooth functioning of modern life. The Specific Relief Act, in safeguarding these agreements, upholds the very foundation of our legal and value system, that is, the principle that agreements must be respected and obligations must be fulfilled. The continued relevance of Sarkar's Specific Relief Act speaks to the dedication of its authors, editors, and publishers. They have ensured that each edition is a reflection of the times, adapting to the changing needs of legal professionals while maintaining the book's core principles. This 19th edition is no exception. It remains a trusted guide in understanding not only the law, but also the spirit of the law. One thing the authors of this commentary understand very well is that at its core, the Specific Relief Act is about honoring the sanctity of contracts. It is deeply intertwined with the principles of the Contract Act, which reflect the importance of upholding one's word. Not only does it exhaustively comment on the 2018 amendment and the associated challenges, it also sheds light on the contemporary judicial interpretations. I thoroughly appreciate how this new edition offers a more nuanced global context with commentary that contrasts the Indian approach with international best practices. As I conclude, I would like to take a moment to acknowledge the significance of this book launch. In celebrating the 19th edition of Sarkar Specific Relief Act, we are not only honoring a book, but also celebrating the role that law plays in shaping our society. Legal texts like this one serve as pillars of knowledge, guiding us through the complexities of our legal system. I extend my heartfelt congratulations to the authors, publishers, and everyone who has contributed to this monumental work. May this book continue to enlighten, inspire, and educate legal professionals for generations to come. It is my hope that this 19th edition will stand as a beacon of knowledge, a testament to the enduring power of law to shape and guide society. I would like to sum up with the thought-provoking words of the celebrated jurist, my brother Viswanathan will appreciate Lord Denning of when he said, and what he remarked was said, without books, law is silent and justice is dead. I wish you all a successful and insightful journey as you continue to explore the depth of this extraordinary book. Thank you very much for giving this opportunity to share my views with all of you. Thank you very much. Thank you. Good evening.
Thank you so much, sir. If I could now request all the guests on the dais to please collectively unveil the book. I'd like to invite the publishing house to say a few words and offer the vote of thanks.
Good evening, everyone. It's a privilege and great joy for me to extend the vote of thanks to the guests here. It's an honor for us at LexisNexis to be part of this lovely evening, graced by the distinguished personalities and wonderful audience. Sarkar, I believe a lot has been said about the book already, so and some great words as well. But I just want to say that the Sarkar Specific Relief Act is a legal classic and has significantly contributed to legal jurisprudence in India. We are delighted to have this edition, authored by Mr. Sudipto Sarkar himself and Mr. Sidharth Sethi. We are sure that this new edition will be deeply cherished and adorned by one and all. I would like to extend my sincere gratitude to Justice Surya Kant and Honorable Justice Viswanathan and other distinguished members, and many of them, from the bar and bench for taking out time and being here with us. Thank you once again, and I wish the author all the best, and request you, I guess, to join the high tea. Yeah. Thank you.
If I could just request Mr. Sarkar to felicitate Honorable Mr. Justice K.V. Viswanathan with a small token of our appreciation. If I could request Mr. Sagar to please join us and felicitate Justice Sanjeev Banerjee. Just request you for 2 more minutes. Honorable Retired Justice Aftab Alib, if you could just please join us, sir. We would also like to felicitate you for your presence